My name is Kim. My name is Kim Amiee, and I'm the owner of KMA Human Resources Consulting. We are delighted today to welcome both Amiee Blanchard Parsons and Fran DeLuca from the law offices of Ogletree Deakins. Both Amiee and Fran are highly respected attorneys who bring a wealth of experience helping clients navigate complex HR challenges across a range of industries. Amiee is licensed to practice in Maine, New Hampshire, and Texas, while Fran serves clients in Rhode Island and Massachusetts. Their deep expertise and practical insights make them an invaluable resource for employers facing today's ever-evolving workplace issues, which here at KMA, we've seen a noticeable uptick in employee misconduct, or I'll say, or employees behaving badly. And we have been engaging with our clients on more and more workplace investigations than ever. Given the current climate, we felt it was a perfect time to host a webinar and bring in the experts to share their perspectives and guidance on this timely topic. So during the presentation, if you have questions, drop them into the chat, and Amiee and Fran will try to get to them, but if we don't have time, they have offered generously to have you email them and they will get back to you timely. So without further ado, welcome everybody to today's webinar, and I'm handing it on over to Amiee and Fran.
Hi, everyone. Thank you again, Kim, for that lovely introduction. And I'm going to hop right in so that we can make sure that we cover everything that we want to talk about. As Kim mentioned, it's absolutely true that investigations are on the rise. We're seeing many more of them. They're becoming increasingly more sophisticated in terms of AI and employees who are using, fabricated emails and all sorts of things that we're now seeing in investigations. They're really an integral part of your defense as an employer. So it's very important that you get your investigations right and that you know how to handle them from the get-go as concerns are rolling in. One of the reasons why we're seeing such an uptick is a little bit twofold, actually. We still have a lot of remote employees, and it's sort of been our experience that the longer folks remain remote and work with colleagues who they don't necessarily know personally, it sort of breaks down their ability to understand appropriate behavior and how to communicate on Zoom meetings. And we've lost a lot of that interpersonal contact that allows people to behave respectfully and talk to their colleagues respectfully. Another, on the flip side, issue is we have a lot of employers who are requiring their employees to come back to work. And these employees who are suddenly required to be in the office, a couple days a week or all through the week, they've also lost touch with what's appropriate and how to interact appropriately with colleagues because they've been in this Zoom context for so long. So that's, I think, one reason why we're seeing such a rise in internal investigations, basically, as a result of the pandemic and employees interacting in different ways and having to sort of shift and grow and understand what's appropriate in these contexts. But truly, the reason why it's imperative to get your investigation right is because along with the increase in investigations, we're seeing investigation results be challenged. We're seeing expert witnesses called to the stand and listed as witnesses in order to comment on whether your investigation was appropriate. And Fran, you can flip the slide. And basically, not only have we seen more investigations, but we're seeing challenges to these investigations. So you might ask, why are we doing these investigations in the first place? And again, it's to make sure that your employees are aware that you're creating a respectful and fair environment for them to work. We're conducting them also to create a factual record of the decisions that you're making because you may be challenged in court. We're conducting them because your employees expect and anticipate that you will investigate concerns that they bring forward. And we're also conducting them to reduce the risk of litigation, because if you can conduct your effective investigation and appropriately communicate with the parties, you're much less likely to see a charge or litigation arise from what may be a common workplace issue. And I'll pass it to Fran.
All right. So, and Amiee touched on this briefly, but you also want to remember sometimes investigations might be required by law. In the higher ed context, you have Title IX you'll have to think about. And sometimes our policies say that we'll investigate certain types of allegations. And if we do that, we just want to make sure we're applying our policies as they're written. So think about when you approach an investigation, we have all those reasons why we're doing it, and they're all really good reasons. If you do an investigation the right way, it can, as Amiee mentioned, prevent litigation from arising. A lot of times complainants just want to be heard. Even if litigation does come out of the complaint, if you investigated, it could be an easy way or a good way to encourage the other side to settle quickly and for short money. It's also a really strong element of our defense. So how do we establish that defense? Well, first, we show that we maintain and enforce a harassment and anti-retaliation policy. If you haven't looked at your harassment and anti-retaliation policies in a while, it's probably a good idea to brush up on them. Some states have enacted new protected categories. Some states have requirements that your harassment policy has to say certain things, have certain magic language. Anti-retaliation policies are always worth looking at. The EEOC recently updated its harassment guidance last year, and there's a lot in there about retaliation policies. The other agencies also offer guidance on retaliation policies. Agencies we don't think of. The DOJ has a whistleblower program that if your retaliation policy, as it should, covers more than just run-of-the-mill discrimination, retaliation, but broader reports of illegal conduct, you definitely want to look at the DOJ guidance and other agency guidance to make sure you have the most robust retaliation policy, not only for legal reasons, but to really encourage people to come forward. You want to make sure your employees know about these policies, so you want to provide your harassment training to them. Some states have requirements of what the harassment training has to look like. Not every state does, but it's a good idea, even in the absence of an express requirement, make sure folks are aware of what their rights and recourse might be. When the allegations arise, you've got to treat them seriously. Even if you think that the person is just, you know, the local gadfly who's always poking and prodding and causing issues, you want to investigate each one seriously with an open mind, kind of a blank slate. And when you do that, we'll talk about how to conduct an adequate investigation. And you want to reach reasonable conclusions, which we'll talk about in detail later. But the point about reasonable conclusions, it's so critical to remember that in employment disputes, if the employee says, let's say we've determined they committed some type of wrongdoing. If the employee says, I didn't actually do it, you got it wrong, the courts aren't going to say, hey, employer, you have to be right about it. You have to make sure that you were 100% correct in determining, you know, Joe Smith, in fact, engaged in this behavior. That's not the standard. The standard is, did you have a good faith belief that Joe Smith committed this wrongdoing or this infraction? And did you reach that belief through a reasonable inquiry? And that is exactly why we want our investigations to kind of follow the protocol that we're going to go through today. The last part, you want to make sure you're taking prompt and appropriate corrective actions. And those actions have to be calibrated to the findings. And we'll talk about at the end, but it may be, if it's unsubstantiated, just a communication to the complainant that the allegation was unsubstantiated. If the complaint is substantiated, well, we will keep the complainant informed of the result, and then we have to do something to the alleged harasser or perpetrator, and what that something is depends on the severity of the conduct, the frequency of the conduct, prior misconduct, and other considerations like that. So I want to go over very quickly the 8 steps of an effective investigation, and we're going to go into each of these in detail in later slides. So right now, you just have to know at the very beginning, there are 4 steps. There are 4 steps you need to do to level set and make sure you're ready to conduct your investigation. First is intake. You got to field the complaint. After that, take a look at it. Figure out what's being alleged, who's implicated. the different sources of documents or other data you might need to look at or go pull from. You want to consider interim actions. This impacts things like preserving evidence and also ensuring that the conduct that's being alleged isn't continuing while we're investigating. Once you've done that, you need to pick your investigator, and we'll talk about the considerations you should look at when you do that. And then you want to conduct your investigation. That's the second 4 steps. You want to prepare a work plan, have an outline of what you're going to do. You want to collect and review your documents. Once you have the documents, once you've kind of gained as much information you can from those, go talk to witnesses about the complaint, about the documents, about everything you've observed. And you might need to collect documents at that point too. They might say, hey, this person has text messages. So these steps are roughly in order, but it's not 5, 6, 7, 8. It's 5, 6, 7, maybe back to 6, then go back to 7. There's a give and a take depending on what you learn. You got to be flexible. At the very end, once we're done with our investigation, we prepare our report, and we'll talk about what to say and what not to say. And then after that, we take our remedial action. So with that, I will kick it over to Amiee to talk about the preliminary steps before we jump into our investigation.
So intake really is critical. What we hear all of the time from employees who move forward with charges and litigation is that they didn't know who to report to. They didn't want to report to their supervisor because they felt like it was their supervisor who was harassing them. They didn't want to make a report because they didn't have a confidential avenue to make the report, and they're afraid to do that without confidentiality, or anonymity is actually a more appropriate word. So making sure that your policies and protocols are available to employees, that they are frequently, at least annually, trained on all of the avenues that you provide for them to report their concerns and complaints. Providing for multiple avenues is critical. You want to make sure that there is a way for them to report someone in HR if they think it's an HR individual who's discriminating or harassing against them. So creating a culture for safe reporting requires the employer to double down on informing the employees of all their avenues and ensuring that they are retrained on that regularly so that they are aware of all of the ways they can voice their concerns and complaints. You want to assess work sites for employee sentiment about safe reporting. And basically, that's kind of assessing the culture of the work site. We're hearing more and more complaints, related to mental health issues and, interpersonal issues that are a little bit different from the complaints that we heard about 10 years ago. Employees are much more comfortable talking about their mental health, much more comfortable talking about, psychological boundaries and all sorts of things. So we want to make sure employees understand that, yes, you can talk about those things with us and no one's going to retaliate or, point their finger to you in the workplace. Training on harassment and the reporting procedures is not only critical for the employees, but it's critical for the supervisors and frontline managers. That's another issue that we often see is a frontline manager hears a complaint from an employee and sort of blows it off and doesn't think that it's serious enough to escalate. But really, it's not that frontline manager's decision. And we don't want the frontline managers or supervisors to think that they need to make the decision about whether or not to investigate. We just need to ensure that they are escalating concerns and complaints as they become aware of them. So training your managers and supervisors is also critical. And then explaining expectations in your company policy is, that's sort of goes along with all that we've talked about in terms of creating a culture for safe reporting, making sure that employees know that they have safe avenues, particularly anonymous avenues. Some employers are now considering protocols, related to AI and different sort of IT related, I guess I'd say, investigation procedures. Employees have more questions about, whether you're using note takers, who's going to be on this Zoom meeting? Is there an AI bot present? And so some employers are actually going as far as to include that in their company policies so that employees understand that there is a protocol related to the use of AI in these investigations. And the next intake slide talks about, the critical steps being your first contact with the complainant. Now more than ever, as I explained, we need to be sensitive to complainants who, are either struggling with mental health issues or might think that their mental health issues are directly related to the workplace or some sort of harassment that they're suffering from. And, we need to understand that employees today are aware of, psychological boundaries and barriers, and they may be very hesitant to talk to you unless you come across as, comfortable and as providing an anonymous and secure place to talk about what's going on in the workplace. An opportunity to reduce the litigation by addressing the issue in-house is, again, going to, an employee who feels comfortable talking to their supervisor or talking to an HR business partner or having their complaint addressed in-house within, their workplace is much less likely to move forward to the Human Rights Commission or the EEOC to file a complaint of discrimination. So if you can conduct a prompt and appropriate investigation in-house and resolve the issue that is, bothering the employee or not bothering the employee, you're much less likely to see a charge. It's also important to recognize that your complainants may be very emotional. They may be scared, they may be angry, they may be confused. And again, it's incumbent upon us, even though we're not therapists or mental health providers, it's incumbent upon us to understand where they're coming from and what their mindset may be, because what we see now is very different from what we saw, again, 10 years ago. We didn't hear of employees talking about their mental health at work. So the last slide on intake and working with the complainant is sort of related to that. Even though we're not therapists, you do need to make sure that you focus on empathy and listening. And the listening piece is critical because you're getting the information that is the complaint from this employee. So you want to make sure that you present as an empathetic, caring individual so that that employee can feel free to provide you as much information as they can. When you have that first interaction with the employee, you don't want to challenge the information they provided. You don't want to say, oh, so-and-so does that all the time, or, oh, that's how Joe behaves. That's just Joe. So, we're hearing that a lot, that employees say they went to report something and it was brushed off as, oh, that's just Joe. That's not intentional. He doesn't direct it, or he's not directing it toward you. So it's really important for you to listen, for you to withhold or stand down on any sort of challenges or interruptions to what they're reporting to you. You don't want to start questioning their motivations. Some employers have, preconceived notions about why an employee might be complaining. Some employees may, have performance issues, and maybe the employer is worried that this complaint is just a way to insulate that employee from performance management. So you can talk about that all in the background in the context of the investigation and the follow-up after the investigation. But your first interactions with the complainant should not involve questioning their motives or even questioning their motives in your head. It's important not to promise an outcome. You don't want to say that, oh, we'll resolve this and you'll never have to work with her again. We'll resolve this and we're going to separate the two of you and this won't ever become an issue. Because unless you know that you're going to find that the harasser or discriminator is culpable, you don't know that you're going to be able to separate these two employees. So you want to ask questions to make sure that you understand what they're complaining about. And again, right along with the listening is allowing for silence to make sure that the complainant has shared with you everything that they can share factually about what happened at work and why they're reporting to you. And in terms of getting the factual claims and not just the allegations, the distinction here is, and we see it a lot in charges and pleadings where complainants are saying, I was subjected to a pervasive culture of discrimination, I was subjected, to a hostile work environment. We hear employees using that phrase all the time. What you want to get down to is, why did you feel that it was a hostile work environment? What about your work environment was hostile? Please give me all the examples that you can give me about, what you perceive is a hostile work environment, or what you perceive is a pervasive culture of discrimination. So you want to drill down and make sure you get the facts, because that's what we're going to investigate. Fran referred earlier to previous reports. It's important for you to talk to that complainant initially and ask, have you ever reported this before? Because sometimes the situation has been reported a few times to a frontline manager who's failed to escalate it. And you need to know that, because you may need to be disciplining the frontline manager or the supervisor who failed to investigate it. It may be that they've reported it previously and the allegations were not founded. So it's important to understand whether this is the first time they're coming to you with a complaint. It's also important to ask whether they've done anything to put an end to the conduct that's bothering them, because sometimes we're talking about really silly things. Sometimes we're talking about an employee who says, I have to work in close confines with this coworker, and she wears really strong perfume every day, and it's making me sick, and I'm having to leave early because I'm getting headaches. And that's a situation where it may be that the complainant can simply ask her coworker, hey, can you stop wearing the perfume? It's bothering me. It may be that someone of one generation is working with someone of another generation and uses language or phrases that, Gen Z or millennials would find inappropriate relative to Gen X. So it's always important to encourage your employees to speak to, their coworkers first. And so you do want to find out, if she asked him to stop referring to her as this, and try to resolve that amongst the coworkers, because sometimes it's no big deal. Identifying the potential for ongoing harm is really important as well. If we've got, something that sounds like it's borderline assault, or if it sounds to you like this is a situation where these two cannot work to each other during the pendency of the investigation, you may need to consider separating them, or even talking to the complainant about whether the complainant wants to be on a leave pending the investigation. So these are all important considerations when you're intaking a complaint, particularly identifying the facts and being sensitive to the complainant.
So once you've identified the complaint and you understand the details, it's time to assess. Do we need to investigate? So that's a two-step inquiry. The first step is assume what the complainant has said is true. Think about the boy who cried wolf. Maybe there were times in the past when this complainant gets worked up over nothing. Maybe they exaggerate. But look at this complaint right here in front of you and say, let's assume it's true, not taking into account the fact that the complaint's a little quirky and out there sometimes. If everything that the complainant has said would give rise to a legal violation, or at least be grounds for discipline, you need to investigate. And the reason for that is we don't want to assume. We don't want to assume that there wasn't a legal violation based on what we know, or based on what's likely, based on what we suspect or assume. We need to get to the bottom of it. If there isn't a legal violation or grounds for discipline, it might be a good time for a policy reminder, just to let the parties who have been implicated in the complaint know, here's our expectation, here's our policy on X, Y, and Z. You might want to disseminate it more broadly to a department or a shift for a couple of reasons. Number one, you don't want to necessarily single somebody out all the time. And number two, if one person is having an issue meeting this expectation or complying with this policy, it's possible there might be a misunderstanding in that department on that shift about what we need them to do. You want to look at the situation in hindsight. You know, let's look back. Let's think about if we were to get a complaint, we were to go to court, how would it look if we didn't investigate? And with that in mind, if there's any gray area, if it's maybe this violates the law, maybe it's grounds for discipline. A good example would be Amy's perfume example. So if an individual with a disability says, I can't be around somebody who wears strong perfume because it bothers my asthma, say that could potentially be a legal violation. But let's say the perfume isn't necessarily bothering somebody with asthma or an allergy, it's just irritating. You know, is being susceptible to perfume absent some kind of specific medical condition, a disability? Maybe, maybe not, kind of on the fence. It's gray. But what do? Just do an investigation. And it doesn't have to be the investigation of the century. You don't have to bring in, a former United States attorney to do it. You can just have a supervisor perhaps say, are you wearing perfume? Are you guys working in close quarters with each other? And if the answers are yes, you technically just investigated, document it, and I'll come up with a solution. Maybe it's stop wearing the perfume, or maybe it's could you work in this other area away from this person? But there are things you can do to investigate that are short of this full-blown kind of what you might see on TV type investigation. One thing you want to think about is, do you want your investigation to be privileged? At a high level, a privileged investigation is an investigation that a lawyer conducts or directs. If it's privileged, it means the investigation and all the work product is confidential. So it would not be disclosed in any subsequent proceeding. We can't be compelled to disclose those facts, those documents. If a court or an agency really wants to see them for whatever reason, too bad. They're shielded by the attorney-client privilege. If you retain an attorney to do this type of investigation and they're well-versed in conducting investigations, they can structure it in such a way that it's privileged, but if we end up wanting to waive the privilege, maybe for a defense, maybe for PR purposes, but if we want to waive the privilege and make our investigation public in some sense, they can structure the report so that it will be amenable to that kind of waiver, opening it up without giving away too much of the background and the nitty-gritty that we might not want to be out there. They would separate, for instance, their factual findings, which we might want to reveal and waive the privilege on, from their recommendations, which we might want to keep privileged, notwithstanding the disclosure of the investigation report. The thing to keep in mind, big picture, you can always waive the privilege. You can make a privileged investigation public. You cannot do the opposite. So if you start investigating and you say, oh boy, this is looking pretty bad, we want to wrap this up in privilege, you can't pick up the phone at that point and call me and Amy and say, can you guys rubber stamp this? It doesn't work that way. We would have to start at the outset to make the whole investigation privileged. We'll talk to later when selecting an investigator on determining whether we do want to have a privileged or unprivileged investigation. But for now, think about the two big buckets. Privileged means we can protect it from discovery, from disclosure, although we can always make it available if we want. Non-privileged means we can't protect it from discovery or disclosure. The other side is going to get it in litigation. The agency is going to get it. And we can't slap a privilege label on it after the fact by having Amy or me, scribble our names on the top of it. So while we're investigating, we want to think about interim actions. So these are actions that are necessary to reduce risk during the investigation, protecting people, evidence, and preventing new issues and complaints from coming up. So the perfume example, for instance, maybe separate them temporarily. Maybe ask the person who wears perfume, don't wear your perfume anymore. Think about ways to keep the issue from reoccurring and causing more harm. Preserving evidence, you might want to put a litigation hold on emails, on other types of electronic repositories of data that could be overwritten or deleted. One common area that people often forget about is video recording or audio recording. So if a phone system is at issue and you work in a regulated environment where phone calls are recorded, just make sure that those recordings aren't going to go anywhere. I see the issue come up more with videos. Most surveillance systems, video systems, overwrite the data very frequently. I've seen as short as 48 hours. I've seen as long as 60 days. But they usually do overwrite because videos are a massive quantity of data. So you want to prevent a potentially relevant video from being overwritten, destroyed, and lost forever. Reassignments at different shifts or locations, that's a good way to separate the complainant from the alleged harasser. And administrative leave. You might want to suspend the alleged harasser if the allegations are sufficiently severe, pending the outcome of the investigation. Selecting an investigator. It is so important to make sure that your investigation to an outside observer will appear and be, in fact, impartial. You want an impartial investigation. So there are kind of two different considerations to think about here. Do we want a privileged or non-privileged investigation? We talked about that before. Do we want an internal or an external investigation? So internal would be you have folks at your company, maybe they're HR, maybe they're in compliance, maybe it's an upper level supervisor. They could conduct an investigation. If there is a potential that the allegations go so far or so high up the corporate hierarchy that it would be unlikely that anyone below the hierarchy could be impartial. Let's say they're accusing an upper level executive or a top salesperson of some really bad conduct. It's possible a jury, an agency would say having a person who reports up to the accused conduct the investigation looks like a conflict of interest. It's going to taint the investigation. If that's the case, you want to kick it out to an external investigator. When you're picking an investigator, you want to make sure they are going to be neutral, they're well trained, and that they have the availability to jump on this when you need to. If you have a third shift, right, you're going to need an investigator who's going to be available to investigate a third shift allegation. I typically like investigations to be in person. You get a better sense of someone's credibility. You want to pick somebody who can get there at the site, in the factory, in the office, quickly, promptly to start this investigation up. On the privileged, non-privileged piece, if the allegations or there's potential for serious reputational harm, that is when I would say you definitely want a privileged investigation. Lawyers know how to ask questions. They conduct investigations all the time, either internal or for litigation purposes. And again, we can wrap it up in a privilege that if we kind of like where this is going and we like our result, we can say, hey, we're waiving the privilege, we're making it public now, but we can protect it if we don't really want the result to be public. So now that we have kind of the 4 preliminary steps down, I'll pass it over to Amiee for the first of the 4 steps that you can take during the investigation.
So setting the scope is important. You want to document, on your notepad or your computer, your laptop, whatever you're using. You want to make sure you have all the factual claims listed so that you know what you're going to ask each of these witnesses. You can organize it by allegations. You can organize it by supporting factual claims. You can organize it by witnesses. But the point is that, you want to have a plan and a scope when you're going into this so that, the investigation doesn't go off the rails and have you talking to 30 people unnecessarily. It's important generally to keep the workplace, moving along. And so the fewer people that you have to disrupt or contact in order to conduct an effective investigation, the better. If you can get the information that you need from 3 people, there's no reason to talk to 6 people. So making sure you set the scope of what it is that you're actually investigating. You know, you're investigating a claim that Bobby Joe is hostile and is always tossing his keys down and slamming doors and staring at employees and making them feel bad. If that's the allegation, that's what you want to be investigating. You don't want the scope to get derailed to something else where, you know, Jenny was involved and Jenny was okay with the slamming doors because she was slamming doors too. So if you're investigating Bobby Joe, keep investigating Bobby Joe and limit your witnesses and keep the scope tidy. You may want to look at the documents. Sometimes this involves looking at a lot of emails. We're seeing investigations involving more and more data these days. We see employees who are iMessaging each other throughout the day, sending repeated emails. So having a thorough review of all the documentation that you've collected and reviewed allows you to understand, what else do I need to know? You know, I see this is all available in the documents. What do I need to ask the witnesses? And then specific to the posture of the investigation, really that sort of helps you plan the scope as well. We have offensive investigations and defensive investigations. Offensive investigations are investigations that arise when an employee complains that her coworker is engaging in misconduct. You know, her coworker or her supervisor is allowing her coworker to show up late every other day. You know, her supervisor is allowing some coworkers to, you know, clock out early, or the supervisor is, you know, not appropriately disciplining a coworker who's using foul language in the workplace. So an offensive investigation is when you go in and say, we need to find out, is this going on? And if it is going on, what do we do about it? So that's a different scope from a defensive investigation where an employee has already made a claim, and you are conducting the investigation because there's been a charge of discrimination filed. And you're investigating at that point because there may be liability litigation wise. So an offensive investigation happens earlier and should put an end to the need for a defensive investigation if you conduct it properly. And, you know, if discipline is required at the end of the investigation, you want to make sure that, as Fran said earlier, it's calibrated to the misconduct. You know, you're not going to move straight to termination for an employee who, you know, used one foul, you know, piece of language once. But if you've got an employee who is frequently using foul language and has been counseled about this many times before, et cetera, you're going to take, you know, a stronger disciplinary action. So to the extent that you have to discover whether employee misconduct is occurring and resolve it, that should hopefully put an end. But to the extent that you've already found yourself with a charge of discrimination and now you're having to go and investigate something that you didn't even know was happening. You know, this employee has filed a charge saying I was subjected to a hostile work environment, but she never complained to you when she was at work. And so now she's quit and you're having to figure out, wow, what happened? And again, as Fran talked about, do I want my investigation report to be privileged? Because, you know, it may be my defense when we go to the Human Rights Commission. It may be my defense when we go to litigation, you know, to establish that this employee did not communicate that she was having problems until after she resigned from employment. So identifying the legal element of the claims is something that you may need to involve counsel on. Really, more often than not, you're trying to understand whether there are violations of policy and whether misconduct occurred. So to the extent that you find that there is, you know, a violation of the law, then you do want to check with counsel to have some guidance on the completion of your investigation. And you can move along to the next slide. So this is, you know, in detail, the offensive investigation is you want to make sure you know what workplace rule is involved. Is it a rule that says employees are not allowed to wear, scents in the office? Is it a workplace rule that says everybody has to be clocked in and at their station by 8 a.m.? Is it a workplace rule that says, you're not allowed to waive your lunch break? So looking at workplace rules and understanding what you're trying to figure out is important. And then making sure that the employees have knowledge of the rule. You want to make sure that you cover that during the investigation. It's important to establish that you have policies and procedures and workplace rules, and this employee was trained or provided with a copy of your policies and procedures and workplace rules. So the employee had knowledge of what he was supposed to do or not supposed to do. So that's important to establish in your investigation and to include in the report. It's important to talk to, again, the fewer number of witnesses, the better. So if you can get evidence of the employee's conduct from 3 people, that's appropriate. There's no need to add on to it, and talk to other people if you've got clear and consistent stories from 3. You may get a story from 1 employee who is the person who would know whether that conduct occurred or not, because they're working next to the alleged harasser or discriminator. So that's a judgment call that you're going to have to make, but there's no need to get extra evidence if you have clear and consistent evidence from 1, 2, or 3 employees. You can use the interview to gain admissions. I mean, you can ask the employee, were you provided a copy with the workplace rules? Did you have an opportunity to review them? Were you trained on them? And that's an opportunity to get the employee to say, yes, I'm trained on these annually. Or the employee might say, no, I had no idea there are workplace rules, which will lead you to investigate somebody else, because it would be a problem that you would determine during your investigation, but it may be that you have to handle something with a supervisor separate and aside from the investigation of the misconduct at hand. And then again, determining the correct level of corrective action is important. You want to be consistent amongst all employees. So if we're talking about an employee who, routinely is not wearing the appropriate uniform, or, coming to work with messy clothes, when you have a rule that says, you need to be presentable in clothes because you're dealing with customers or you're a customer facing employee, you want to make sure that you're imposing the same discipline on all the employees who break that kind of rule. You also want to make sure that if it's a habitual offender, it may be more significant corrective action than if it was, a first-time offense of showing up in messy clothes or showing up, without the appropriate uniform. And it's important to allow the employee to explain why he or she did what they did. Because even if you've made the determination as you're talking to this employee that he or she did in fact break the rule, you want them to provide an explanation of why they did it. It may be that his or her frontline supervisor was charged with training them on some rules, and that supervisor didn't train them, which that opens the door to investigation of that supervisor. But you want to understand why they did what they did, and whether or not that means that you need to investigate anything else or dig into anything else. It also, leaves the employee feeling that he or she has been heard. You never want to conclude an investigation without the employee telling their own story. And then in a defensive investigation, that's where we're talking about a charge of harassment, discrimination, retaliation. That's when we have an employee coming to you and saying, I'm being treated differently from the rest of the people, or, I'm being treated differently from the men in my department. I'm being treated differently from, other people in my department based on my sex, or, my need for leave, or because I previously reported complaints. So those elements are elements that you may want to be checking with counsel with if you're looking at a charge, because a defensive investigation, again, is going to be used in your defense once you proceed to litigation. And really, that is what the employer is relying most on, is to show that they conducted a prompt and effective investigation. I know it was in the chat and it's come up earlier that, what do we do if we can't figure out, who was leaving nasty notes on her desk? What do we do if it's inconclusive? We can't figure out who was leaving racially motivated notes on this employee's desk. That's fine. It's okay if you can't figure it out. The key is to make sure that you're documenting all of the steps that you're taking in order to figure it out. Make sure that you document, I talked to 7 witnesses who had access to Jane's desk, and none of those witnesses saw anyone go near Jane's desk between the hours of 4 and 6. So making sure that your investigation report reflects your thoroughness and your diligence, making sure that it reflects that you acted promptly to investigate the employee's complaint of harassment or discrimination is key. So finding out whether or not something happened in this instance, you may not be able to find out whether it happened. But what you can do is thoroughly document all the steps that you took to figure it out, and also thoroughly document your communications to the complaining employee afterwards. The complaining employee may just say, I just want to move to a different shift. Is it an option for me to move to a different shift so that I don't have to be near him? Because, you may not have been able to validate it, but I don't feel comfortable working with him, particularly now that I've complained about him. So those are sort of like interim actions that you might need to consider before the investigation, but they are also actions that you might take following an investigation that was inconclusive, when you have an employee who still feels unsafe or uncomfortable going back into the work environment. And then let's see, do I have a next slide? I think this is you, Fran.
This is me. Moving on to the next step of the investigation, we have our work plan. We know what we're going to do. We know what we need to do. Let's start collecting documents. So you want to make a list of the documents you'll need to collect and review. As I mentioned before, your document collection is kind of an ongoing process. This step and the next step of conducting the interviews, they're kind of interwoven. If an employee mentions a document that you hadn't thought of or you didn't know of during an interview, go and get it. And then conduct follow-up interviews based on what you learn in that document. You want to spot missing facts. I can give you a really kind of egregious example of this. I had an investigation once, a sexual harassment investigation, where the complainant gave the investigator, me, text messages from her phone. And they looked pretty bad. They were repeated sexual remarks and comments from her supervisor with no response from her. They looked completely unsolicited. There were some things in there that looked a little suspicious. It was almost referring to a prior statement that she had made. It almost looked like a response. So I saw that and I went to the accused and I said, "Did you text her?" And he admitted, point blank, absolutely. And I said, "Did you say these things?" And he said, yes. He wasn't lying. He was very honest. I was a little surprised. And he said, "But did you see what she said to me?" And he gave me text messages from his phone that were the full conversation. She had deleted messages that he had sent her, that she had sent him, kind of inviting these questions, inviting these comments. She deleted them and only provided one side of the story. When you got the full picture, you saw the missing facts and you saw that this was actually consensual. So look at things that might lead you to believe there's something else out there that I want to look at. Maybe an email refers to a text message, or maybe an email refers to some other document that we want to go look at. Maybe an email refers to video footage. Think about ways to fill the gaps in documentary evidence. The more documents you have, the more contemporaneous documentation you have, the more likely it is you'll be able to reach a definitive conclusion at the end of your investigation, which is what we want to do if we can. And as you're doing your interviews, make sure you're keeping a list of not only the events, but also personnel who was involved. That might be a place for you to look in determining, do I need to conduct more interviews, or where can I go for these documents or more documents? All right, so the types of documents to collect, obviously written complaints from the complainant, incident reports if security or some other department had observed some of the misconduct or they had observed similar misconduct. If it's something that involves a close working environment, think about the perfume situation. Maybe we can get a diagram of the work area to see how close they really are working together. You want to collect the relevant policies that you have. Your harassment policies, your EEO policy, retaliation policies are typically the ones you'll start with, but there may be others depending on the type of allegation. The org chart, you might want to see if there's a reporting structure or hierarchy that would give rise to claims of undue influence. You want the personnel files, both for the accused and the accuser, the complainant and the alleged harasser or alleged wrongdoer, to see if they have a history of similar issues, and that will inform later on the steps you might take to remedy the complaint. And you also want to look at emails and also social media. I don't want to spend a ton of time on this because we're coming up on time. We only have about 8 minutes left. But last year, the EEOC released updated harassment guidance, and it gave examples of when something that happens outside of work, on work time, on social, outside of work, on personal time, on social media, can be part of a hostile work environment. The EEOC didn't say you as employers have to go out there and police everybody's Instagram and Facebook and X account. But they did say if you learn that folks are engaging in harassment on a protected category outside of work, and it relates in some way to issues that are happening at work, it could be part of the environment. So do check social media to see if any of that stuff is going on during your investigation. And now I will give it back to Amiee to talk about how to conduct our interviews. Oh, Amiee, you're muted.
I'll be speedy. The important thing here is that you want to identify how the witness wants to talk to you, how the complainant wants to talk to you. Is this something that you're doing via Zoom, or is this something that you're doing in person? Obviously, we talked a little bit earlier about how there are pros and cons to both. If you are doing this in person at the work site, you want to be very careful that it's taking place in a private, confidential setting. You don't want to parade the complainant across the factory floor or, across the workplace or through the restaurant. You want to make sure that you handle it discreetly, even if it means, going out of the back door, or contacting counsel or contacting someone at KMA, or figuring out where you can do this off-site if there's no way to conduct it confidentially and discreetly on-site. So being discreet is critical, both for the complainant and for any of the witnesses. And that goes along with feeling safe and supported. Nobody wants, the whole factory floor or the whole shift to know that they're talking to the investigator or human resources. In terms of handling third-party invitees, this is really different from what my response would have been 10 years ago. 10 years ago, I would have said, no, you can't bring your spouse or your partner to the interview. No, your spouse or partner cannot be sitting with you. But we've moved to a different sort of world right now in terms of people's psychological and mental health. And I really look at it, from the court or jury's perspective. How is the jury going to feel if this person was suffering, from harassment for a long time by a close coworker, and we made her sit in a room by herself and she couldn't bring her husband for emotional support. Even though the investigator may not want the person there, you may need to consider allowing that person to bring their emotional support person, because a jury may not be very happy with you, to the extent that you make them come into it blindly. And in 2025, that often seems more harsh. And then determine how you're capturing the interview. Are you taking notes on your computer? Are you writing notes? Are you using AI and the note taker function during a Zoom meeting? All of those are important considerations when you think about how you're actually going to conduct it and where you're going to conduct it. And then moving along, I think we've covered most of this, but you want to drill down on each of the allegations. You want to get the facts. You want to ask questions like, help me understand this. You can certainly ask the witness, do you think there is anybody else I should talk to about this? Are there any other documents that you're aware of, like emails from another employee that I might need to review? Is there anything else that you want to share? So make sure you drill all the way down and confirm that you've gotten everything that you can get from the complainant or the witness that you're talking to. And it's critical to also say, hey, if you think of anything that you want to talk to me about, feel free to contact me. Here's my phone number or my email. You may, remember something after we talk today, and, don't hesitate to reach out. I'm happy to talk to you during the pendency of the investigation. So just doing everything that you can do to reassure them that, the communications are confidential to the extent that they can be, and they will be used to create a report, and making them feel safe and secure. And I think, Fran, I'm passing it quickly to you.
Thanks, Amy. And now let's wrap it up with the last step, preparing our investigation report. It's our report. The purpose is to inform an employment decision. Did this misconduct occur, and what are we going to do about it if so? You have to assume that this report will be viewed publicly. Think about how a jury would view it. Because of that, you want to explain your findings in factual phrasing and using factual determinations. Think about the slide that Amy talked about earlier, where the allegation might be, I'm the victim of a hostile work environment. You probe down, what's the factual allegation? My boss called me a hot little chorizo, I think it said. If that's the allegation, our conclusion shouldn't be your boss called you a hot little chorizo and that was in fact a hostile work environment. We don't want to reach that legal conclusion. Let's just focus on the factual allegation of what was or wasn't said. And the reason for that is if you say, and this is a hostile work environment, or this violates Title VII, that could very well become Exhibit A at a trial, blown up on a 5x7 white screen, shown to the jury. The company concedes that XYZ conduct violated Title VII. That would be a very bad exhibit at trial. You want to reach an outcome. Amy mentioned, let's try to corroborate or not substantiate. Let's try to make a definitive conclusion. But if we can't, we have to explain everything we did to try to get there. So-and-so said only these people had access to the desk from this time to this time, and no one was observed there. We want to at least say what we did if we were not able to get a definitive outcome. Think about writing it as an explanation to the losing party. That's one good way to look at it. We want to make sure it satisfies any legal requirements. There really aren't a ton of legal requirements. Some states like Rhode Island will require you to tell the complainant about the outcome of the investigation. That's a good practice anyway, but it won't require you, and I can't think of any law that requires you to divulge your report or give away any personnel information pertaining to a third party, even the accused harasser or wrongdoer. Finally, when you prepare it, you generally want a good format of what you did, the allegations, the evidence that you looked at, and that includes who you interviewed, your analysis of that evidence, including credibility determinations, and then our conclusion. Remember, there's a difference between privileged investigations that attorneys conduct or at least oversee, and confidential informations, which are just the ones that we do without an attorney internally, or it could be externally through KMA or some other party qualified to conduct an investigation. And now in our last minute, Amiee will wrap it up by talking about appropriate remedial action.
So communication is vital. You want to follow up with the complainant and let the complainant know either that you've taken appropriate action without revealing what that action is. If there is no corrective action, you want to assure the complainant that you're monitoring the situation, and you want to remind that complainant to come back to you if anything else happens in the future. So you can make sure that you communicate that to the complainant, and then if you're imposing corrective action on the respondent, you need to handle that personally with the respondent. The complainant doesn't get to hear what the corrective action is. They often ask for it. They often, move on with charges and say nothing was done about this, but you are not obligated, and you should not share the corrective action with the complainant other than to say we've resolved the situation. So communication to both parties is vital, and taking consistent action with what you found in the report is also vital. So reviewing your current policies, confirming that employees understand the reporting avenues, training your internal investigators, and making sure that your frontline employees understand to escalate complaints, and then establishing protocols for your investigation process so that you can follow a protocol and remain consistent with each complaint that you receive. And I think that wraps us up at 101.
All right, so I guess we're all set. I think we are available. I think you'll be getting this deck very shortly. And if you have there were a lot of questions we couldn't get to. If you have them, you can feel free to email us. We're happy to follow up with you and respond to whatever your burning investigation questions might be. But thank you for joining us for this Lunch and Learn. We both really appreciate it and enjoy spending some time with you.
We'll get that out to you later today. Thanks, everyone. Have a good one.
Thank you.
Bye.